On the 23rd of March 2016, the Amending EU Trademark Regulation entered into force. It changed the name of the office to the European Union Intellectual Property Office. It also changed the name of the trademark that we administer from the Community Trademark to the EU Trademark, along with other changes to streamline proceedings and increase legal certainty. Fast forward to the 1st of October 2017, when the remaining parts of the regulation, as well as the new secondary legislation, the Implementing Regulation and the Delegated Regulation, start to apply. They bring with them a series of changes. The first change is the abolition of the graphical representation requirement. A trademark won't have to be represented graphically, as long as it is represented in a manner that enables the subject matter of protection to be determined with clarity and precision. This means that certain types of trademarks that can be represented in electronic format only are now acceptable. The new implementing regulation lists new categories of trademarks and rules and requirements for the representation of the most popular types of trademark. Full details of all the categories are available on the EUIPO website. Another change, the EU certification mark. It's a new type of trademark at EU level. It serves to certify that goods and services comply with certain standards. There are procedural changes too. Hand deliveries and post-box deposits will no longer be accepted by the office. In certain cases, online substantiation of oppositions and cancellations is possible. For this purpose, the Office recognises all of the databases of the national and regional EUIP offices, and TMView is acceptable as a portal through which the national and regional offices may be accessed. Acquired distinctiveness can now be a subsidiary claim, allowing the applicant to exhaust their right of appeal on inherent distinctiveness before it's required to prove acquired distinctiveness. There are new provisions on belated evidence of substantiation and proof of use. Translation requirements are significantly simplified to facilitate procedural economy and lower costs all round. Where an agent or representative registers an EUTM without the proprietor's authorization, the proprietor is now entitled to demand the assignment of the EUTM as an alternative remedy to invalidation. Transitional provisions set out when the new rules take effect. A new provision, which mirrors the General Court rules, requires that evidence attached to submissions must be clearly identified, indexed and referenced. For more information, check our website. We have a special area dedicated to the legislative reform. Stay tuned for our webinars, and you can get our updates on Twitter. Remember the hashtag EUIPO0110.